This is the third and final in the Human Rights and Housing series. So this has been a wonderful series, and for those, some of you may have been with us for all three, or you may be joining for the first time today. Either or, fantastic to have you aboard this afternoon. Before I do anything else, I would like to acknowledge the traditional custodians on the land on which we are facilitating this webinar, which are the Turrbal and Yagara peoples. I would like to pay my respects to elders past and present. I especially welcome and pay respect to all First Nations people joining us online today. If you would like to, it'd be great if you could take a moment to use the chat function to say where you are joining us from today. I'd also like to acknowledge that we meet on stolen land because sovereignty was never ceded. Okay, I'm very proud to be joined today by representatives from the Queensland Human Rights Commission, or QHRC. Dr. Joseph Hongo is a Principal Dispute Resolution Officer with the Queensland Human Rights Commission. Joseph is an established facilitator, mediator, trainer, and monitoring and evaluation consultant in the area of resolution, peace building, and international development. He holds a PhD in governance and conflict management from the University of Queensland in Brisbane, Australia. And Joseph has worked in Africa, Asia, and the Pacific, including Kenya, Uganda, Tanzania, Burundi, the Democratic Republic of Congo, South Sudan and Rwanda, the Philippines, Papua New Guinea, and of course Australia. Rebecca Leong has joined the Queensland Human Rights Commission as a principal lawyer in the Legal Research and Policy team in 2019. Rebecca has considerable professional experience in the community legal sector, including as Principal Solicitor of the Queensland Advocacy Incorporated, which is an organisation advocating for the rights of people with disability. Rebecca has a Bachelor of Laws Honours and a Bachelor of Science from the University of Queensland and has worked in the private, community and government sectors in Queensland and overseas. So thank you both very much for being with us today. So workshop one, for those who did not attend or for those who attended and would like a bit of a recap, we had a look at the purpose and scope of the Human Rights Act and looked at the 23 sections of the Queensland Act. We learned some essential terminology and concept related to human rights law. We started to have a look at how the Act can be applied to your own organisation's responsibilities. And we had a go at looking at the human rights compatibility assessment and the process behind that, which I think is super useful, even if you're not a public entity, that you can use that when making decisions in your workplace, when you're wanting to put new policies in place or making decisions about in terms of housing and assigning housing and things like this. Workshop two. So we built upon the first workshop. So we left, well, I hope that you all left with an enhanced understanding of how the Act applies to decision making and service delivery. We looked at, in quite a lot of detail, Section 13 of the Human Rights Act, which is looks at the process of limiting human rights and how and when some human rights can be limited. We developed confidence in identifying and addressing human rights impacts. And again, we looked through the process of the compatibility assessments. Just to, you know, if you're not familiar, but hopefully you will be by now, we have 23 protected human rights in Queensland, and some common ones that we see being engaged in our work would be protection from torture, privacy and reputation, cultural rights of Aboriginal and Torres Strait Islander people, right to education. Obviously there are many more, but they are some of the common ones that we see. You should all be familiar with the dialogue model, which is how each arm of the government has a responsibility in either making and changing laws, putting laws into action, or interpreting and enforcing the law, how human rights has to be a foundation and a tool being used in all those decisions. And as I mentioned earlier, in last session, we did talk a lot about Section 13, discussing how human rights may be limited, which can be, which I guess is a good lead-in for today's section of complex decision making. So just as a quick refresher, under the Act, compatible with human rights means that an act or a decision does not limit a human right or limits a human right only to the extent that is reasonable and demonstrably justifiable. So, and I've highlighted the important parts of that statement. Section 13 of the Act provides guidance on when human rights may be limited and the factors to be considered when assessing if an act or decision is compatible with the human rights. Human rights should only be limited after careful consideration and in a way that can be justified in a free and democratic society based on human dignity, equality, freedom, and the rule of law. And the human rights compatibility assessment is a tool or process for that careful consideration. Okay. So quick overview of today. Next up, Rebecca and Joseph will be sharing their expertise and wisdom with us, which I'm extremely grateful for. So thank you to you both. We will have time for a question and answer section with them. And then we'll have a short break. Then we come back for some group discussions. We will also be joined by Matilda, Alexander from the QAI, the Queensland Advocacy for Inclusion, and our own Bronwyn Kippen, who will share some insights as well. But the second half of this workshop is really about an organic conversation, hearing from you about what works in your organisation and what resources you would like to see. So I think it'd be a really important section of this workshop to gain some, I guess, learnings from your peers, as well as contributing things that you might want to see. Okay, without further ado, I will stop sharing my slides and we will hand over to Joseph and Rebecca.
Thank you very much, Charlotte, for that wonderful introduction and for the invitation. I also want to acknowledge the traditional custodian of the land on which we gather here today. I'm in Mianjin, land of Yagara and Turubal people, and I want to acknowledge the elders past, present, and emerging, and to acknowledge the work they've done and their contribution to making this country a wonderful place to be. I also want to recognize the my colleagues on this teams today. Thank you so much for taking time out of your busy schedules to be part of this process, and also to acknowledge and thank my colleague and partner in crime here, Rebecca, for being part of this. So today we're going to talk about the more detailed human rights beyond what has been covered in the past two workshops, and also delve into the complaint process. And Rebecca will share with us some of the wonderful legal issues that are important in this space. And I think to just start, you might wonder, why should we care about human rights? I want to say, first and foremost, it's a human thing to do. Caring about human rights is human, and whether Section 13 applies or not, I think is the right thing to do. But beyond that, as public entities, it's incumbent upon us to pay our respect to the legal obligation, in that we have to make decisions that are compatible with human rights. But also, it also makes us good international citizens. We don't want to be barbaric towards the people that we serve. And so caring about human rights has the element of building yourself as an international good citizen. Again, part of the building human rights culture in Queensland is to be able to improve decision making in public sector. So again, considering human rights in all decisions, whether you're going to make a decision that in a way does impact on someone negatively, then you also show that you've considered their rights. It also helps in safeguarding against improper use of government power. We know the state can sometimes be excessive in power, and you don't need to be told about that. You just have to look at what's happening in other parts of the world. And so when we have the Human Rights Act and we adhere to the principles, then we are also doing our part in checking the excessive of the state power. And in doing so, we improve accountability, reduce complaints, hopefully. But even beyond that, we do show respect for human dignity, especially in government decision making. Again, a lot of the work that the complaints we come through and the work that we do, we come across a lot of vulnerable and disadvantaged members of our community. And so when we care about human rights and we make decisions incompatible with the Human Rights Act, then we are also paying attention to the people that we care about, the vulnerable community, and make their life better. So it is a natural thing. It is human, and it's our obligation to care about human rights. So with the Human Rights Commission, we administer 2 acts, and Charlotte, I'll talk briefly about the Anti-Discrimination Act because it's connected to the Human Rights Act. So we have Anti-Discrimination Act 1991. It does provide comprehensive protection against discrimination, sexual harassment, and other breaches such as vilification. It provides a clear framework for the complaint process, and the conciliation is part of that. Where a complaint is not resolved under the Anti-Discrimination Act and the complainant wants to proceed, they have an onward path to the tribunal. So under the Anti-Discrimination Act, a complaint, and sometimes we receive complaints from complaints involving housing that are covered under the Anti-Discrimination Act, and sometimes where they're not resolved here, those complaints sometimes end up in the tribunal. We also have the Human Rights Act, which again provides protections against human rights breaches. The difference between this and Anti-Discrimination Act is that there's no right to referral to the tribunal. So under the human rights process here, if a complaint is not resolved, and I'll come back to that later, the complainant cannot directly refer the matter to the tribunal through the commission. They can explore other issues such as challenging decision in the Supreme Court, but not through the Anti-Discrimination Act. And the lawyer here can assist me with that. The beauty about Human Rights Act is the flexibility it provides. As you must have heard before, it has the inbuilt dialogue process. Now, dialogue process means that in this case, you give the public entity a chance to explain the decisions or clarify the decisions. It is more flexible. And the idea here is to build a culture of human rights through dialogue. So, and that's very, very important when you approach Human Rights Act from this perspective. So, the complaints process under the Human Rights Act. So, under Section 65, a complainant cannot directly lodge a complaint with the Commission. They have to, first of all, make an internal complaint to the public entity concerned. Now, that has 2 important functions. One, it allows the complainant and the public entity to resolve the matter internally before it comes to the Commission, or rather coming to the Commission. But more importantly, it also allows the public entity to build a culture of human rights by constantly looking at those complaints, making decisions, reflecting, and the more you make decisions, you reflect, the more you build a culture of human rights in public entities. And so where a complainant has lodged a complaint with a public entity, the public entity has 45 business days, and they can engage in dialogue with the complainant, and in some cases, those matters get resolved. It's not easy to know which ones get resolved because we don't get to know those complaints when they have been resolved. However, where a complaint has been lodged with a public entity and it hasn't been resolved, or it has not been resolved, the complainant's interest, or in a way that the complainant desires, or there's no response, Then the complainant can make a complaint to the QHRC. The complaint will be analyzed and assessed, and if it is accepted, we do begin a process of trying to resolve it, and that's through a dialogue model that can take exchange of information between the public entity and the complainant to try and find pathways for resolution. It can also take the form of a conciliation conference to try and bring the parties together to have a respectful discussion in a confidential space to exchange views and try to resolve it. Where a complaint is resolved, the parties can agree to write a conciliation agreement. They can agree to resolve it through dialogue, and the matter ends there. Now, in some cases where a complaint is not resolved, the Commission might issue will issue an unresolved complaint report and may include recommendations. And the word there is may. Not every complaint that we receive and is not resolved result into recommendations. So that's very, very important to note. Now, what are some of the outcomes that are possible here? Now, you will appreciate how the challenges of housing in the present day Australia or even globally, and the issues we come across, and so I'll come back to that shortly. But there are a range of outcomes possible under the Human Rights Act, depending on the situation and the issues raised. The complainant can receive an apology to acknowledge the hurt they have experienced and the distress. In some cases, an outcome might involve a change of a decision, a reversal of a decision, or an action in respect to the decision that was taken. It might also be that it might result into the client's change circumstances, so being moved to a different area in the case of housing, or being provided with a different accommodation, or being provided what they sought in terms of the complaint to the department or to the public entity. There can also be a policy change or agreement to implement a policy or change a policy, review the policies and to ensure that they are compatible with the human rights, and also to ensure that the policies really respect or respond to the issues raised. Now, as I said before, where a complaint is not resolved, the QHRC will issue a report that might contain recommendations on what actions the public entity needs to take in order to comply with the Human Rights Act. Now, this graph will keep changing. It's not definitive, but you can see the range of complaints that the range of rights that we come across related to the housing issue. You will see that recognition and equality before the law, Section 15, is by far the largest. That is because under our process, if a complaint is accepted as under the Anti-Discrimination Act, there is the piggyback process that allows the complainant to also make a complaint of limitation of human rights under Section 15. So most complaints, actually all complaints accepted under the Anti-Discrimination Act also have the Section 15 of the Human Rights Act as a piggyback.
Provided it's a respondent as a public entity.
Yes, sorry, that's a very, very good clarification. Provided the respondent is a public entity. And then you have privacy and reputation down to freedom of movement. So this is some of the range of rights that we come across in relation to the complaints involving housing. Yeah. Now, what are some of the common issues we come across? This might not be new to most of you who have been in this space. We receive issues about the behaviors of other tenants that affect the complainant, and those tenants might also be tenants of the Department of Housing. And so depending on a case-by-case basis, it might be that a tenant is named as a respondent and the department as well. So it could be an issue of vilification, victimization, but it depends. I cannot say this is a specific one. It depends on a case-by-case basis. And so in some cases, it's a pure human rights complaint. In some cases, it's a complaint under the Anti-Discrimination Act. And there are individual tenants named as a respondent, and the department also named as a respondent. The other issue we come across a lot is people, especially those living with disability, seeking to be moved to a suitable accommodation in order to cater for their needs. And this could be mobility issues, it could be mental health issues, and so they seek accommodation that is suitable to their needs, and also might be suitable to the services being provided, so that they're able to live independently. We also come across privacy complaints where the complainant is alleging that the tenants are using devices to film them or to surveil them, and that impact on their privacy and the reputation as well. There are some cases where people want to change geographical areas because of their situations, circumstances. But the department is saying that no, we are not able to provide you with that request because we don't have sufficient stock, or there are not available places where you're seeking. And it could be because they also have they're living with a disability, or then there's an issue that is under consideration that requires them, or rather makes them need to move to a different area. We also come across situational complaints where there are functional public entities who are providing housing in partnership with Department of Housing, or there are under arrangements like that. And there could be discrimination areas of impairment, family responsibility, or others that come under the Anti-Discrimination Act, but also they have the human rights element attached to them. Again, this is not surprising to many people. We do come across complaints that involve breach of notices, eviction, people on waiting list, and in most cases, these are also complaints where someone is living with a disability, and as a result of their situation, so for example, they have a condition that makes it harder for them to be quiet or be silent, and so there could be a breach of breach notices because of noise, but that noise or whatever that is because of their disability, and so they sometimes face eviction, and then they complain to us. In some cases, they face eviction and then they're put on waiting list and they need to be prioritized. And so they're seeking the intervention of the Human Rights Commission to try and see how their situation can be taken care of. Again, this, as I said, the housing issue is a complex issue, and it's on a case-by-case basis. Yep. So what are the benefits of pursuing a complaint through the QHRC? One of the biggest benefits is that it provides an opportunity to discuss the issue of the department, or rather the public entity concerned, and to try to find solutions. Now, our desire is that parties discuss and find a solution before they lodge a complaint, partly because sometimes this process can be time-consuming. So it provides the complainant, especially where they don't have a strong voice of their own, to have a discussion with the respondent or the public entity to find a solution. There's also the possibility of negotiating terms, including someone being being pushed to priority in terms of waiting, or backdating the waiting list. So we can negotiating to see how can we make your situation better. How can we try to find some urgent solution where it is possible. Again, where the complaints are lodged here, the department becomes aware in detail of the complainant's situation. So in most cases, this is where the complainant is living with disability, complex disability, and they may not have disclosed this to the department for other reasons. And the department just says them, oh, this is someone who just wants to be prioritized. So when they come here and parties have a discussion, things get clarified, the department is aware of the issues at play in more detail, and they're able to cater for the complainant's needs, especially if the complaint is resolved. And so again, in some cases where the complaint is resolved, there's the benefit of maintaining ongoing relationships. Again, in most cases, it is good if the complainant, being a tenant, and the department or the housing provider are in good relationships. And so a resolved complaint provides an opportunity for having an ongoing relationship in a way that it's not adversarial, and it's one that leads to independent living and better living for the complainant. Okay. Sorry. There are challenges, of course. biggest challenge is that currently we are facing a housing shortage, and so it is difficult to get what you want immediately. So the ability of the public entity concerned to move the complainant or make accommodation to meet their needs is not always easy. Sometimes you see cases whereby the public entity say, look, if we had stock, if we had a house, we can provide it. But again, the situation is that we cannot provide one now and in this situation. So in such cases, it might force the complainant to change their desired geographical areas. So if you're in the north side, you might say, look, why don't you expand to include south side, or why don't you expand to include other places? Those are some discussions that take place, but the reality is it's not easy in the current circumstances to provide urgent accommodation, especially that meets the specific needs of the complainant in some cases. You also, in the reality where there's no right to housing or to secure housing, and that becomes a challenge in terms of enforcing some of the requirements or providing a solution that is immediate. In some cases, you do find that in lodging the complainant may not have thought about what realistically they want to achieve from this process. Again, that's very, very important. When people lodge a complaint, it is good that they know what do they hope to achieve. So sometimes the range of outcomes that they hope to achieve is not possible within this process, or is not possible given their situation. One of them is people always, not always, sometimes someone might seek financial compensation, and that may not be possible for public entities. They might want to negotiate in terms of providing alternative accommodation or trying to make arrangements to get accommodation urgently, but they cannot do so or at the same time provide compensation. The challenge here is that by the time the complainant comes to us and the complaint is with us, they feel that they have spent a lot of time and sometimes money. They feel that they've suffered a lot, and they might seek compensation for the pain and suffering they have gone through in the past. So you find that the complainant might be seeking both past and future remedy, while the public entity is more to look, we acknowledge that what you've gone through, we wish we could have done things differently, but here we are, can we find a solution about moving forward? So sometimes the request to get that financial compensation may not be available, and that might be a sticking point in some cases. There's a lengthy waiting period, not just for providing housing, but also in our processes. So by the time someone lodges a complaint, it gets assessed and then sat down for a conciliation. It takes time to resolve. I mean, again, there's a legal process. There are timelines that need to be adhered to. So we cannot receive a complaint today, set it down tomorrow, and resolve it the following day. And so in some cases, you may come across complainants who really have urgent needs, but the process is not geared towards an urgent, immediate provision of service or provision of remedy. So in some cases, you find that complainants genuinely bring issues to us, but without knowing how the process works, they look at timelines that they cannot live with because they have urgent needs that are important, and so that becomes a challenge. Again, we also come across vulnerable people who are not legally represented, and all they want is a place to live. All they want is their circumstances to be addressed. All they want is a change in circumstance. And so you find that they are vulnerable. We need to be impartial at all times. And so as a dispute resolution practitioner or a conciliator, on the one hand, you're trying to provide a space for the complainant to voice their concerns and be heard and find a solution or work an outcome. But at the same time, you're doing so within an impartial position. And so you always have to juggle these two competing positions. You don't want the complainant, you don't want the power imbalance to play so much in a process. But at the same time, in leveling the playing field, there is also the perception that you might be favoring one party over the other. In some cases, even when you try to address the power imbalance, one party might feel that you haven't done enough to provide them with that support. That can also be quite a big challenge. Again, as I said before, rarely will the department find immediate solution. And that sometimes for those who have really significant health needs, for those who have significant requirements and support needed, it becomes difficult to provide immediate support. In the other issue that we come across sometimes is where the department has, or rather, the public entity or the department views the situation differently, and the complainant has an NDIS package that views the situation differently. And so you might find a case whereby it's not clear who is supposed to be providing what under what terms. And that sometimes can be really a big challenge, especially where what we are looking forward to is an outcome that parties can live with. But when you are in that middle where there's NDIS part here in terms of providing independent living, but also the department also has a different view of the same, it becomes a challenge. So before I hand over to my colleague here, is just say, look, the Commission, it's important for parties to know that the Commission is a dispute resolution entity in this process. We don't have thorough investigative powers or determinative powers. Sometimes we come across complaints where someone say, I want you to investigate and find fault. We can't do that. So it's good that parties know who we are and what we can do. That helps in terms of knowing whether this is the right process for their complaints, or a better process might exist and they might need to seek legal advice on that. But also it helps them know that if they are coming through this process, what do they hope to achieve? And do they know what it takes for that? So once again, thank you so much. And I will turn over to my colleague and looking forward to your questions. Thank you.
Thanks so much, Joseph. Let me see. Yes, I can use the technology. So we're going to change gears a bit because I'm here to talk more perhaps about the legal side of things and some case law. So please stay with me. I want to throw our minds back to where Joseph started and thinking about why do we care about human rights? Why do we apply them beyond just knowing that it is a legal requirement under the Human Rights Act as public entities to make sure we're making decisions and acting compatibly with human rights and giving proper consideration to human rights. And we know, and we've seen in the court cases, that where we don't comply with those obligations, that the courts can come in and say, well, that decision or that action was unlawful, and overturn that decision, and then that has, can have significant impacts for the individual affected, but also for the decision maker as well, and the decisions that they've made in relation to similar circumstances. So what I thought might be helpful today is just to give some case examples of which I think give good examples of why using human rights can be really helpful to public entities. Unfortunately, there hasn't been any, I don't think, strong. I think there's been one or two tenancy cases in QCAT that have talked about human rights, but the ones that I'm talking about today aren't specific to housing, but I hope you find the fact scenarios useful in any event and analogous to the situations you might be seeing. So the first one I'm giving as an example of supporting sound and thorough decision-making, and it's the case called DR&YO and the Department of Child Safety, Seniors and Disability Services. So they've anonymised the child parties in this case, and it's a 2023 case that was decided in the Queensland Civil and Administrative Tribunal. In that matter, the tribunal was being asked to consider an application to stay a decision of the department to remove 3 Aboriginal children from their long-term foster care placement on the basis of allegations of harm against the children. And the proposal was that the children will be removed from their long-term foster carers and be placed in the care of their aunt. And the aunt also lived in the same coastal town as the children's mother. So there's obviously positives about removing the children to such a place in terms of family reunification and being closer to family. The tribunal looked at human rights in helping them to make the decision. in favour of the children remaining with the foster carers. The tribunal considered that the children had expressed a wish to stay with their foster carers. They had been in the community for a long period of time. They were well integrated into that community, and they were well supported with education and health services. In relation to the harm allegations, the tribunal noted that the allegations of harm had not yet been tested, and also that there was work that could be done to mitigate that harm, such as, the department could conduct more regular visits and produce safety plans and other measures. On the other hand, the tribunal considered if the children were to go back or to go live with the aunt, that would be supportive of rights to family and also rights to Aboriginal cultural rights in terms of kinship care, or connection with kin rather. In terms of cultural rights and promoting access to understanding and learning cultural practices or being on country, the tribunal actually looked at the evidence of whether the aunt was in a position to teach the children about cultural practices or share cultural practices, and that they noted that there had been no evidence led about that, and also they noted that the country or the town where the aunt lived wasn't actually the children's country, so that also wasn't a persuasive feature of the case. So at the end, in those circumstances, and remembering this was a stay of a decision to remove the children from long-term foster care, the tribunal actually decided that while there was some limitation of rights in the children not moving in with the aunt, those limitations were actually justified and reasonable in the circumstances, considering how well they were going in their current foster care placement. And also the children had expressed a wish to stay with their foster carers at that stage. And this was just going to be a temporary decision until, longer term orders and evidence could be investigated. So that was that decision. The next decision, I've called it a common sense check. I toyed with the idea of calling it a sanity check of your decision making. And it's just a short little example. So the case is called Youth Empowered Towards Independence Incorporated, and the Commissioner of Queensland the Queensland Police Service. And you might have seen this in the news maybe, but this was a case where we call it a writ of habeas corpus, which is a fancy term for an application to the court to get somebody out of detention. And it was made to the Supreme Court for the urgent removal of 8 children who were being held in a watch house. And the application was to remove them from the watch house to a youth detention centre. And there were human rights arguments raised, but actually at the end of the day, the case succeeded in favour of the children because the QPS couldn't actually establish that the court had issued the orders authorising the lawful detention of the children. So the court said, okay, well, you should have this order to say you can remand the children in the watch house. Where are they? And the QPS weren't actually able to provide those orders. And so I just thought, if you think about Section 13 and assessing compatibility with human rights, the first question is the decision lawful? And they hadn't actually checked that off their list. If they had been giving proper consideration to human rights in their decision making and holding those children in the watch house, one of the first questions you would ask yourself, is it lawful? And you can find the order and you can hold the children in the watch house. So maybe it's just a bit of a safety. It can offer a safety check and make sure that we're applying common sense to our decisions. The next case is a bit hot off the press. It was only published last week. And it's the case of Anderson and President of the Parole Board. And I'm using this as an example of how human rights can help us apply our existing legal frameworks. So in this case, the substantive content of this case was about the Parole Board making a decision in relation to a 70-year-old prisoner who was in ill health. And the order that was made would prevent him from applying for a parole until he was 78 years old. So 8 years, no parole period. And a key feature of the case was how many health issues he was experiencing and what that would look like in 8 years' time if he wasn't able to apply for parole beforehand. And the test in making this decision for the president of the parole board, the test that he was to apply was he could make the order prohibiting application for parole if he was satisfied it was in the public interest to do so. So he had to apply a public interest test. So the court held that the public interest requires consideration of the interests of the affected individual by the decision, because decisions with devastating consequences call for genuine consideration of the human consequences and demands honest confrontation of what is being done to people. So in effect, looking at the human rights of the person who would be affected by the decision. So in this case, no one was disputing that it's called a restricted prisoner declaration, and no one was disputing that that declaration was there was justification to make that declaration. The key issue was, should it have been made for 8 years when he was in such poor health? And the court said the president of the parole board did properly consider the risk to the prisoner, the risks to the community if the prisoner was to be released, and the support that he would require if he was released. But the parole board had not given any reasons for why they imposed the term of 8 years, 8.5 years, and they didn't give any consideration to how the prisoner's declining health would be managed within the prison. So it was the court's view that the president failed to give genuine consideration to the human consequences of the duration of the declaration and the effect it would have on the applicant, and therefore the decision was invalid in that it involved an error of law. So that case demonstrates, in that piece of legislation, they're meant to consider the public interest, and in this case, human rights was part of the matrix of considerations that should have been considered. All right, so finally, identifying potential for systemic change. So I got, unfortunately, this isn't a Queensland case. It's a Victorian case from 2024, but I'm going to use it anyway. And it's a coronial inquest case into the inquest of the passing of XY. XY was a child. They were 17 years old. She was an Aboriginal woman, and she died while under the care of the Department of Families, Fairness and Housing. The reason why I'm raising this case is that the coroner used human rights as a lens in which to view the multitude of interactions the state and its delegates had with the deceased person. And if rights were limited in those interactions, looking at whether there were alternative pathways available, and those alternative pathways might help identify recommendations for future prevention opportunities. So as an example of how the coroner did this, the coroner looked at evidence that the department did not action court orders for XY to have contact with her siblings. And this was in the face of XY's own repeated desire to see her siblings. And the coroner said that at the very least, the department should have documented in some detail why this contact with siblings was not possible. And so the coroner held that this was a failure to consider XY's views, and it was a breach of her charter rights to the protection of her best interests as a child. And so the recommendation that the coroner made on the back of that was, and I'll read it out in full, the department should review and revise its relevant training courses and programs with a focus on improving child protection practitioners' skill in engaging with children and young people so as to hear, acknowledge, understand, and give weight to a child's experience and expressed views in their subsequent decisions and actions. So that's using a human rights framework and lens to try and identify ways of working in the future. And I think that's some of our goals when we're doing conciliations and receiving complaints under the Human Rights Act at the QHRC is to try and help public entities find ways forward to avoid those situations from arising in the first place that might be incompatible with human rights. So we do hope that we're moving towards facilitating that dialogue and coming up with those solutions. Just for the last part of my presentation, I thought it might be good just to spend some time thinking about how do we embed a culture of human rights within our own organisations. You might be aware that embedding a culture of human rights is one of the 3 objectives of the Human Rights Act in Section 3, and the Section 3 relevantly says to help. One of the objects of the Act is to help build a culture in the Queensland public sector that respects and promotes human rights. And this quote that I've put on this slide is an interpretation. This is from I think it's 4Gov. There's a Department of Justice website which has all the resources about human rights. And they've defined building a culture of human rights as a pattern of shared attitudes, values, and behaviours that influence the policy-making, decisions and practices of government to uphold the human rights of all Queenslanders. The Queensland Human Rights Commission, so every year we publish an annual report, not our corporate annual report, but we've got an actual separate Human Rights Act report where we have to report on the application of the Human Rights Act each financial year. And in that report for the past 4 or 5 years, you can see that we've developed these indicators of a human rights culture within organisations. And each year we survey a selection of public entities and report against these 7 indicators to try and get a sense of, are we progressing in time against these indicators? So what we've identified as indicators of human rights culture is looking at what's the education and staff development, what kind of community consultation and engagement about human rights is the public entity having, is there awareness raising and support for related entities, has there been, and this won't apply to functional public entities, but has there been a review of legislation and subordinate legislation or local laws in compliance to demonstrate that they are compatible with human rights? Reviews of policies and procedures within the organisation for human rights compatibility. Is there been an internal complaint management of human rights complaints, like an accessible and effective internal complaint management process? And finally, what are the future plans to further the goals of the Human Rights Act? You might be aware that under the Human Rights Act, there was a statutory requirement to have an independent review of the functioning of the Human Rights Act, and that was conducted last year by Professor Susan Harris-Rimmer, and this report was tabled, and that's the beautiful front cover of her report. Although the recommendations she makes within her report were not going to be implemented by government, I thought some of the I've changed the recommendations to suit the audience here, but I thought some of the recommendations that she makes that are relevant to embedding a human rights culture might be useful to think about. So one of the things that she recommended was that government, or in this case, public entities, should have a public statement of their commitment to human rights, and that there's senior leadership within an organisation that champions human rights and promotes the value and importance of that within the organisation. Designated human rights roles, we're all always short-staffed, and it's hard to get people focused on particular areas when you're just so busy delivering frontline services. But one of her recommendations was if there could be someone within organisations that have a designated responsibility for promoting human rights within the organisation, and then also that role having contacts and links and collaboration with similar roles in other organisations and having a community of practice around human rights. The report also recommended that there be initiatives that promote that ensure that human rights initiatives that promote human rights are recognised and celebrated. So offering incentives and feedbacks to promote human rights respect. And then finally, supporting staff to receive the customised training. So that was one of the key features of her recommendations, that it's not just general training, but having, focused training that will really help staff understand their obligations in the context and framework of their own work. And then also understanding the value of applying human rights. And that's where we started our conversation today. Why do we apply human rights at all within our work? So that brings me to the end of my bit of the conversation, and we can open it up to, I'll stop sharing my slides now and we can open it up to questions if there are any.
Maybe start with this one first.
Yep. Thanks so much, Joseph, and thank you so much, Rebecca. That was really insightful and really valuable. I learnt a lot. We've already got one question from the audience. So Wendy asks whether those 7 KPIs are publicly available for us to adopt.
Yes, absolutely. So go to our QHRC website and you'll see it's a bit buried. I'll try and get the link to Charlotte, and when she circulates other materials, maybe she can circulate it,
Sure.
or I can probably put it in the chat during the break. But yes, if you can find our annual reports, our Human Rights Act annual reports, and you can see how we've sort of analysed the survey answers that we receive in response to that framework. But I think it's really useful just to try and monitor within our own organisations, where are we at, and are we thinking about these issues and embedding cultures of human rights. So that's great. I'm really pleased that you're interested in the indicators.
So if anybody would like to ask Joseph or Rebecca any questions, feel free to raise your hand and you can verbally ask something, or we can stick to chat or mix it up a little bit with both. Nick's just
Yeah,
put up a
probably. Probably. Yeah, our website's undergoing some restructure, which will be great once it's finished, but at the moment, I'll just link all our, that's probably it, Nick. I'm sure it would be, but if you want to see sort of our analysis instead of just the oops, no, that's not going to work. Sorry, I'll get the
For those listening to this recording later, Nick has just asked whether he's shared a link and asked whether this is the information that Rebecca was referring to earlier. Does anybody have any questions? So
I've just shared the link to all our Human Rights Act annual reports if you want the analysis part of it as well. And
for those, again, listening at home, I will send this in the post-event email, so everybody will be able to get this if they're interested, which of course you are. We've got a question from Christopher. Please feel free to speak.
Yeah, I was wondering, you were talking about, it being a long-term game, I guess, around the reporting stuff. And it may not be suitable for people looking for quick solutions. What do you guys do and suggest in that space for solutions around getting immediate responses?
In relation to somebody who's got an individual complaint where some action is being taken that's impacting them now, and they want sort of a quick turnaround?
Yeah.
Yeah.
Yeah, thanks a lot, Christopher. I think it, again, to use a common term, it depends on a case-by-case basis. But I think the first thing will be to discuss with the public entity concerned to find out what information they want. So if, for example, just an example, someone is living with disability, they need to be provided with an alternative accommodation that takes care of their needs and their situation. What we see a lot is that in some cases, they have provided the department with limited information. And so the department is unable to make a decision that will in some way be in their favor. So sometimes trying to find out what information is needed by the department, how that information can be provided, so that the department is fully aware. In most complaints we come across, the department may not be aware of the full extent of someone's situation in order to provide that priority consideration. Where the complaints come to the commission and we assess them and convene a conciliation conference, what we try to do is to see to do a problem-solving approach to see, okay, who needs what and what can be provided. Because what we find in most cases is that where a complaint is not resolved here and potentially ends up with the tribunal, or it is it's not resolved and a report is issued, the complainant in most cases is the one who loses, because it's a lengthy process. So we try to see what can be achieved within this process, and it's a negotiation process. So sometimes it's about what someone can live with, rather than what they will have hoped in full extent to achieve. So again, it's a case by case basis, but a lot of cases is that it is the point of that limited availability of information that allows a particular situation to be dealt with urgently, considering that also the challenge of housing availability. But you could see, and I've seen this conference in conciliation conferences, where if there's a pathway to a solution that may not be perfect, but it's a pathway all the same, the public entities, especially the department, are always willing to see workable solution. So you find that it take that problem-solving approach rather than finding fault or compensation. So again, it's a case-by-case basis, but I think it depends on what the issue is and the extent to which the complainant is able to look for or to consider alternatives. So for example, expanding the range of places that they can live in, expanding certain provisions that they need so that they can the stock can increase. It's ultimately it's always about the stock and where it's available and how it can be provided. I know it's a lengthy question, but I hope you can add something.
Yeah, I was going to add, and correct me if I'm wrong, Joseph. And sorry, Chris, if you're going to say something else, but I think from our perspective, we always appreciate too when we receive a complaint, we don't need pages and pages of information. We don't need evidence.
Yes.
We just need enough facts to be able to understand the complaint. So things that often we see missing from complaints, which makes it tricky and it lengthens out the time because we're having to come back and forth for asking more information. Things like dates is really helpful, like when did things happen, and identifying, what's the primary concern of the complainant, like what's because sometimes people will come to us and there's a lot of things they want to talk about, and obviously there are a lot of things that are concerning to them, but once you do have a chat with them, it becomes clear that there's one particular thing that they're really that's their main goal, and if we can focus down on that. The other thing I just wanted to add is that we do have a triage process within the commission, so we do assess everything we receive as quickly as we can get to it, and we can pull things. We can try and resolve things sooner if the urgency requires it. And I'm just thinking back to COVID days, when people are stuck in hotel quarantine, but they couldn't manage the situations that they were in because of disability or mental health, and we were actually able to resolve some of those issues quite quickly. Because we were able to point out to the right people, this person has been inappropriately placed in a hotel room that doesn't have the things that they need because of their disability. So, that's all I wanted to say. Sorry, Christopher.
So essentially, like, sort of going to the Queensland Human Rights Commission is like a second hand after the conversation with the public entity, because I'm just in a teaching space at the moment, and I'm trying to encourage and best inform my students, around you know, they're always saying, who can you report to as Queensland Human Rights Commission, but they don't understand what that actually means. And yeah, it was just a good insight that they should always try to engage in conversation with a public entity prior to putting them in the complaint.
Yeah, and that is if it's a pure human rights complaint. And I appreciate sometimes the person may not know whether this is a discrimination complaint or human rights complaint. But if they're alleging discrimination in the provision of housing services, then they don't need to go to the public entity first. If they think they can find a solution through that process, well and good. But under the Anti-Discrimination Act, they can lodge a complaint with us straight away. However, if it's a complaint alleging limitation of their rights under the Human Rights Act, then under Section 65, the starting point will be to try and bring the issue to the attention of the public entity, allege human rights limitation, and where possible, they can say this right and this right, and give that public entity 45 business days to try and deal with the issue. And if not dealt with in the way they feel, then they can come to us.
Yeah, the way the legislation's drafted, if somebody makes just a human rights complaint, not an anti-discrimination complaint, we can't actually look at it unless they've made a complaint to the public entity first. And we can speak, we don't have to wait the full 45 days if there's justification not to wait those 45 days. Yeah.
So you guys sort of play a mediation role in that space?
Yes. Conciliation and mediation, and you can do that either through a conciliation conference or through exchange of information, shuttle negotiation, phone calls between the parties to try to find those common grounds and trying to resolve the issue.
Thank you.
Okay, thank you, Christopher. That was really, I think a lot of people would have benefited from that question asked and answered. Hello, Bronwyn. We've got a couple of minutes left before a quick break. Bronwyn, did you want to add something?
I was just going to ask a quick question about the reports. If the complaint can't be resolved and the Commission writes a report and that's provided to the department, does the Commission have much visibility over what the department does after the report is provided?
That is an excellent question, and the answer is not really. We do hear sometimes we're on stakeholder engagement groups and we hear just, through those conversations that yes, they've picked up those recommendations and they're implementing them. But in terms of capacity and resources to follow up the recommendations we make in a formal way, or powers to seek information to see what they've done with those recommendations, we haven't to date done terribly much of that.
Okay, thank you.
But I think even in the absence of that, sometimes the parties participating in a conciliation conference is always an eye-opener. And so you do find that sometimes they take notes during the conferences and look at things that they can improve with or without a report.
Okay, I think we've got time for one more quick question. I think Rose has her hand up. You feel free to ask your question.
Great, thank you.
No worries.
When somebody makes a human rights complaint, particularly around housing, do they need to identify at least one of the 23 areas of complaint or do they just, sometimes they're just so disgruntled? Yeah, how does that work?
Excellent question, Rose. We don't expect or anticipate that the complainant will have legal expertise or knowledge of the human rights area. They just need to take human rights. If they can identify, well and good, but our assessment team are equipped with knowledge and expertise to see the situation of the complaint and will make a decision and identify the human right, even if the complainant hasn't ticked a particular right. They need to tick that they're complaining about human rights, but they don't necessarily need to tick a particular right. But as long as they tick the complaint about human rights, we can have that data, we can receive the complaint. In some cases, based on the information provided, you can check with them whether they're complaining about this and this and this. So the idea is to not knock out the complaint because of technical issue or lack of knowledge. The idea is to look at, okay, this was the situation they're facing, which right might apply here, and then we proceed from there.
Yeah, the form, I don't know if you've seen the form, Rose, but there are, tick boxes that you can do, and it helps. The form's written so that it guides people to answer the information that we need, but actually we can receive a complaint in any written form. So we receive complaints, we just, people email their stories in. They don't specifically refer to any rights.
Yeah.
And we can still assess and accept those rights, complaints for conciliation.
Okay, thank you everyone. We'll have time again, hopefully, at the end of this session, but we'll have a quick break now. If we can aim to get back here in about 5 minutes would be great, because we're going to be joined by another guest speaker. So if I can have you back here about 2:12. Okay, so everyone feel free to have a break and join us back at in 5 minutes. Thank you so much. I'm very pleased to welcome Matilda Alexander today. She is the CEO of the Queensland Advocacy for Inclusion, or QAI, and she's going to give us some valuable insights. So over to you, Matilda.
Thanks, Charlotte. Thanks for having me. Before I start, I'd like to acknowledge the traditional owners of the land that we're on today, the Turrbal. I'm on the lands of the Turrbal and Jagera people, and pay my respects to elders past and present, and acknowledge that sovereignty has never been ceded on this land. I'm the CEO of Queensland Advocacy for Inclusion. I use she, her pronouns, and I'm a middle-aged woman with a blue jacket on and brown and blonde hair for people using visual descriptions. Talking about systemic barriers for people with disability and the housing sector is something I'm particularly passionate about, and even more so today than any other day, because as many of you might have already seen in the news, there was a whistleblower who talked about a 12-year-old boy with disabilities being placed in secure care. So this is a new model of housing for somebody with disabilities. It's something that has been used for adults in the past, disability-based detention, but not for children. So I think that this is a really good reminder. I'll put a link to the article in the chat of the importance of the Human Rights Act in addressing the needs of people with disability and the need for constant vigilance around that. The Human Rights Act itself has specific provision for NDIS service providers who are considered public entities under the Human Rights Act. So that's something that I think a lot of people aren't aware of, and we really want people to know that. So if something happens to you and it's by a human rights, by an NDIS provider, that you can make a complaint, and NDIS service providers have those same obligations as any other public entity to firstly consider human rights properly, and secondly to apply human rights in a way that, for example, might mean the least restrictive option on your liberty, on medication, on locked rooms, on putting away objects and things like that. The threat for people with disability, one of the biggest human rights threats is institutionalisation. So institutionalisation is something we often think about as being in the 70s when we had, massive group homes for people with disability, insane asylums and things like that. But it's actually something that has contemporary application for many people with disability, and attempts at things like cost cutting for the NDIS, which push people with disability into shared supports where they or into restrictive practices are actually a threat to people's human rights. So the UN has talked about this as an issue. The Disability Royal Commission has talked about this as an issue. And it's certainly something that we are constantly aware of and making human rights based arguments with NDIS providers and with the providers of housing for people with disability. Of course, housing for people with disability is also under state housing, which falls under the Human Rights Act as public entities as well. One of the biggest areas of human rights for people with disability in relation to housing is the right not to be discriminated against. So this falls under both the anti-discrimination laws and the Human Rights Act. And it's really important to be very aware of people with disabilities' right to not just to not be directly discriminated against, so refused housing because of their disability, but also indirectly discriminated against. So they can't, so a housing provider has to make modifications, for example, or even private tenants have to, tenancy places have to allow modifications under those laws around indirect discrimination. So it's wonderful to see those embedded in both the Human Rights Act and the Anti-Discrimination Act. And those are rights that you can bring a concurrent action on. So you can bring a Discrimination Act and piggyback a Human Rights action on that. One of the aspects for people with disability in relation to housing is that there's a lot of regulatory bodies. So you've got the NDIS Quality and Safeguards Commission looking at some things. You've got state housing bodies looking at other things. You've got human rights laws. You've got discrimination laws. You've got consumer laws. So there's a lot of different aspects which can be quite confusing, particularly in the disability space, where there can be federal and state and private funds contributing to all of the costs of somebody's housing, and in particular where housing can be linked to care and supports. So one of the learnings from the Disability Royal Commission is that a person's care and support, so the person helping with things like showering, toileting, providing food, providing care, should be different to the person who is providing the bricks and mortar of the home. That was one of the key recommendations from the Royal Commission in order to avoid abuse and neglect. And again, that has been emphasised by the United Nations in its deinstitutionalisation guidelines. So I think that if we're looking at the kind of pointy end of systemic barriers for people with disability, we've got these examples of disability-specific detention. So people detained in forensic disability services, mental health wards, and this young boy that was in the news today, who we've been told is being detained in a specific correctional-like facility, prison-like facility because of his disability. So I think that that example makes very clear the threats to the right to liberty, cruel, inhuman and degrading treatment as well. And in fact, Australia's practice of indefinite detention of people with disability in these kind of facilities has been criticised by the United Nations, specifically around the Convention Against Torture. And Queensland in particular, still does not have sufficient safeguards for monitoring around torture, and has been criticised for the UN for putting in place safeguards that apply to prisons, watch houses and youth detention centres, but failing to put in place those safeguards for disability-specific detention like forensic detention and mental health detention. So that's the kind of really pointy end of human rights issues for people with disability. And then at the other end of things, we've got just the day-to-day people living in supported independent living and specialist disability accommodation, where their service providers may be NDIS providers or people living in public housing with disability. There's high rates of disability in public housing as well, who may have any number of human rights issues. So a common one would be the right to family life. So often it can be considered that a person's funding package is most efficient in a single bedroom unit, which might restrict families from visiting. So just say no visitors after 6 p.m. That's obviously a big infringement on a person's private life and goes towards what we would define as an institutional arrangement, which is what we're trying to get away from. So I think that every little decision around people with disabilities can be looked at from a human rights perspective. A person has, it's been described in the disability community as a burrito test. So if you're in an institution, you can tell if you're in an institution because you can't get up at 3 a.m. and microwave a burrito. Like, it's often locked rooms or locked kitchen facilities or knives or, access to microwaves and things put away at the end of the day. So the idea is, is to just constantly think about when making a human rights framework decision, what is this person's right? What are the cultural rights? What are their other human rights? And how can we be least restrictive in all of those rights? And that test of least restrictive is something that is common across disability legislation, like restrictive practices, and also common across Human Rights Act in the proportionality test. So I think that was about all I wanted to talk about.
No, I appreciate just thinking about, your example of a person being restricted to a certain, like curfew in terms of visitors after 6 o'clock. To look at it as just a simple policy, sort of face value, you think, oh yes, they want to keep that, house quietened down after this particular hour. But if you explore, you can easily see that that does significantly interrupt somebody's ability to live and to socialize and that sort of thing. So I think, a lot of these policies, I think maybe 10 years ago or so, I would have just accepted that that was some, the provider's policy, etc. But I think it's this conversation about how those particular points have such a huge ripple effect on individuals is really important to, so having policy decisions like that and challenging those, I think, is really important. I wouldn't have, I can admit many years ago I wouldn't have even considered that to be a breach of any kind of human right, but yeah, I can clearly see. So I thank you for those examples. We've got, if you've got time, Matilda, we've got a question that's come through from Elaine. I'm going to read it out for the people who are listening to this recording later. She has said, how can we better support people with disabilities needing robust housing to minimise the need for restrictive practices, particularly when the NDIS will not fund further home modifications to robust SDA, and the person does not have sufficient funds to pay for ongoing property repairs they cause due to their complex behaviour support needs, especially when a property just does not meet their assessed needs in terms of modifications?
So I think it is a complex question because it would be different answers for every person. So just for folks who don't know, SDA stands for Specialist Disability Accommodation. It's a form of funding for housing under the NDIS. The answer will be different. So how can we best support people is ask them, how can we best support you? Build up a supported decision-making framework. A lot of work that disability advocates do is with people with disability in these kind of situations. So we might work with the person to say, identify what their needs are, what is causing the complex behaviour that's causing the damage, and how do we address that? So it's kind of hard to give a one-size-fits-all answer because it comes down to the individual and their needs. So if they have a NDIS package, they might have positive behaviour supports plans in there. You could look at those. It might be that this person needs a review of their plan because to take into account additional modifications that they're needing. And it might also be that those modifications should be provided if it's a public housing tenant. It could be that those modifications can be provided by the housing provider. It does get very complex with disability because of that different who's responsible for paying for things is a bit of a gets passed around a bit, but there are answers, you know, in the various laws, and that interface between the NDIS and mainstream housing systems is something that people with disability should not be caught in the middle of that. I guess that quite literal buck passing between different providers and government departments. Like, we should make sure that people with disability have appropriate modifications and housing for all of the needs. And yeah, different answers in different solutions in different cases.
Thank you. Does anybody else have any other quick questions for Matilda?
That was a great question, by the way. It really gets to the heart of it.
Because it takes, I've read cases where the time it takes to if modifications have been approved, the time it can take to actually get those modifications happening is unbelievable. I mean, I don't know, you know, this is, you know, a very obviously specific area, and I'm not an expert, but is that the case in many situations, or is it more that once these, you know, the modifications have been approved, that it's a quick process to get done?
Yeah, and a lot of SDA housing is quite new build, so it should be built according to specific standards of modifications. But again, if you need something that's not that kind of standard build, and one of the things that we're constantly pushing for is there is something called a gold standard disability building code. At the moment, we are only sticking to the silver standard, so housing providers could look at that gold standard and build it right from the first instance, and then that saves having to do modifications later.
Yeah, of course. Well, Matilda, you're welcome to stay for the rest of the discussion, but I know you're very busy, so you're welcome to run off as well.
Thank you.
Thank you very much. Right. Thank you, everybody. I think due to time constraints, we're going to skip through a few things. I just wanted to give some examples of how the Act has been used in Queensland to drive systemic change. So we were talking specifically then about people with disability. These are some examples that the QHRC have provided. So there's a wide range of impacts that the Act has had, even though we know that the Act is, you know, super new in Queensland. You know, we've only been using it for just over 5 years. But in that time, we have seen some, you know, very beneficial impacts. I'm not going to read them all out because we've got time to consider, and I want to get to some discussions and things like this. But I've just popped up a couple here. We're also looking at some reviews and that sort of thing, inquiries as well. So I just wanted to put them up there for you to have a bit of a read, and obviously this the slides will be sent out so people can take more time to explore these when they get the post-event email. But I just wanted to say that, you know, there's a lot of, sometimes there can be a lot of doom and gloom around the issues associated with the application of the Act and that sort of thing. But there have been some really, really positive changes since the Act, including, you know, workshops such as this, and all of you who are attending today who really want to make make sure that they understand best practice and to, learn as much as they can about rights respecting practice to help their own organisations and their clients as well. Okay, so this is the start of hopefully a wonderful discussion. I would like to, if she's still around and still wanting to, QCHRC has a wonderful human employed here by the name of Bronwyn Kippen, and she is the acting Executive Director for Research and Policy, and she just wants to, well, I've told her to get the conversation get the conversation going on how the Act has been used in Queensland to drive systemic change. Over to you, Bronwyn. Thank you so much.
Thanks, Charlotte. Thanks for the nice introduction as well. Yeah, I just thought I would share a little bit about how QCHRC uses the Human Rights Act to support our advocacy and some practical examples of change. And it flows on well from what Matilda was talking about as well, because we have worked on some joint advocacy from a policy point of view for in relation to housing and supported accommodation. But just really briefly, for QCHRC, we do bring a human rights lens to our policy and advocacy work, which means that we kind of integrate human rights into our decision making when we're looking at responding to, say, new legislation or inquiries, for example, like the supported accommodation inquiry. And an example for legislation is recently there have been several changes to the tenancy or the rental reforms, so the tenancy legislation, and we used a human rights lens when we were advocating for changes there to advocate for renters' rights. People have a right to adequate housing, and not that housing is a right within the Human Rights Act in Queensland, but part of the having adequate housing enables or facilitates other rights to be achieved. For example, the right to life with dignity, the right to freedom of movement, particularly in situations where it's supported housing, the right to privacy. That's an issue that kind of comes up in boarding house situations in terms of having security and safe spaces for you as an individual. We do use that. We think about human rights when we are preparing our policy positions. When we're talking to the sector to get feedback, we talk about it we frame it in a way about how are people's rights being impacted, and that in turn helps us to write in a ways that reflect a human rights-based approach to then hopefully influence, legislation and positive change. So to give a really practical, tangible example, one recently with the reforms around the rental reforms is that one of the changes that we did get through was that there needs to be a standard rental application form, because what we were hearing and seeing is that people were being discriminated against. It's such a competitive environment, being asked all types of information that wasn't necessary to assess someone's ability to be a tenant, but really did infringe on people's privacy. It also, sometimes the question asked enabled or facilitated discrimination as well. So part of the recent legislative reforms around the tenancy requirements is a standardised form where a lot of those questions that were potentially previously asked around the nature of your relationship with other individuals on the application and extensive financial information, extensive identification information, they're no longer able to ask for all that unnecessary information. And in turn, hopefully over time, it does result in less discrimination based on people making assumptions on the additional information that was previously being asked for. So I just thought, just to set the scene a little bit, to provide an example from a systemic point of view, we are using the Human Rights Act to try to get changes like that, and it can get right down to that granular level, and also just to reflect what the Human Rights Commission was saying earlier, in that we can embed the Human Rights Act into the way that we work, and by framing our questioning around the Act, it helps us kind of gather that information and then influence from a human rights perspective as well. So Charlotte, that's all I was really going to share in terms of some practical examples. And I can put some of the links to the our submissions in the chat.
That would be amazing. And I can share those too in the email to follow this. Hopefully I'll make a note of that so I don't forget. But that's actually, I don't know if people realised how the impact that may have on renters' lives, because I clearly remember, I mean, and that back in Sydney when I was, applying for rentals, the competition around that, and even the exchange of money and all of those things to the, the leasing agent was just, it was a nightmare, and how much information about you personally that they needed. So that is a huge, so that's in effect now.
Yeah, it came into effect, I think it was the 1st of May off the top of my head.
Oh, okay.
Yeah, so it's a standardized form. Yeah.
Amazing. Well, that's really, thank you very much, Bronwyn, for sharing. Does anybody have any contributions to this particular question that they would like to share? We'd love to hear from you. Or if Joseph and Rebecca, if you're still here, I can sort of see you, but if you're still around, you might have some examples that you might like to share. And Natalie has just shared that it's a huge and important reform for renters, and I definitely agree. Like I mean, we all know that the housing crisis and subsequently the renting crisis is just it's just, I don't even have the words for it, obviously, but it's just it's a nightmare. So these sort of changes will have, I think, a huge impact. Rose has just shared the application form in the chat. Thank you for that, Rose. Sorry, Joseph and Rebecca, if I cut you off and just started babbling about my rental experience. Did you guys have anything to contribute for this section?
I think this is more bringing outside into inside and vice versa. Part of the challenge is that in some cases you do find that a lot of discrimination occur in provision of housing, especially private housing. But in some cases, it's not easy for people to lodge complaints, either for all sorts of fear of victimization or retribution, or they just don't know the way around it, or they just feel that it's not the pressing issue is getting a house as opposed to lodging a complaint. So if you do find that if you talk to people outside, they will tell you the kinds of discrimination they face in seeking housing, either on disability, on race, or other attributes. And that old form or that old way of testing whether you're the right person was part of the discriminatory framework. But you find that people, there's not many people are willing to really lodge complaints, and in most cases, it's through complaint process that some of these things get changed. Because I usually say that people don't want to come here twice as respondents. So those who are in advocacy space, it's good to highlight that, look, there is a chance to lodge a complaint, because if you don't complain, then it is difficult to see changes happening. Yeah.
Yes, that's right. I mean, I think a good thing about the Act, we've established that it is a wonderful tool, that we use it as a lens to examine past decisions that that we're still currently using in our organisations, and any kind of, new reforms coming through. But we do have to speak up, whether, if we can't speak up for ourselves, there are lots of organisations out there who will help to lodge that complaint and have our voices heard. So the fact that we can, make these complaints and to push back on some of the decision makers is a huge positive, change for us in Queensland. Does anybody I can move on. We've got about 10 more minutes for some discussion. I know a few of us were really interested to know what the gaps are currently, and we are also interested in developing further resources that may be helpful to the community sector. I've just had a question come through. I'll just go back to this slide. So Kirsten asks, is there a way that services can support advocacy and reform when people aren't willing to make a complaint? So, you know, she said, for example, capturing the stories.
I can answer that if you like.
Sure, I'd love you to.
Yes, definitely. We are, when we're preparing our submissions to respond, or if there's inquiry or something happening, we're always looking for stories from frontline service delivery organisations to be able to highlight how the issues are impacting people, and the individual stories are really powerful in our advocacy. So we have a research mailbox that I can share in the link that we encourage people to contact us on. But when we are doing submissions, we do try to advertise that on our social media and through our newsletters, and we'll always have a link to contact us if you want to contribute. And stories is a great way, service members can and providers can engage in advocacy and support the advocacy.
You got a thumbs up. All right. Does anybody want to, sorry, I was distracted by some dinging going off on my end. In terms of the gaps that exist in terms of human rights in the housing sector, is there anybody that would like to share some gaps that they are acutely aware of? Yes. Joe has shared houses. Rose has contributed that she's concerned about, tenants experiencing domestic and family violence.
I did mean tenants.
Sorry. I was thinking maybe she's talking about those who are escaping and living in tents.
Well, that too.
Yeah. Yeah.
Bloody hell.
So yeah, there's a huge gap right now in that area. I absolutely agree, and it's I mean, we know that domestic and family violence, just that topic itself, is diabolical and disgusting, and we're not doing enough about it. And part of that is now, you know, also what happens now. Often, you know, it is the victim who has to leave their house, which shouldn't be the case, but it often is. And where do they go? And often they don't go anywhere suitable. I know this as a former domestic violence worker trying to place people seeking safe accommodation. It was nearly impossible. So that is a huge gap. Yes, I agree. Bronwyn's just shared the email that you can reach us on about topics such as this, which is research@qcos.org.au.
Charlotte, there's something that anecdotally come across as well is where, because of the current housing situation, people, even those who are in houses provided by public entities or private entities, when they have issues to raise, for example, someone living with disability needing to get certain modifications, they're afraid of raising those things for fear of losing what they have. So you do find that there is suffering in silence, because if you speak, then you potentially fear of going into the black book or the bad book.
Yeah.
And that means that you may not get your issues addressed in the future if you need. So you hear people talk, those who have lodged a complaint, and in the conference they highlight, look, this was a huge undertaking for me. There was risk I was taking in making this complaint because I was afraid that if I put forward this complaint, then I might lose A, B, C, and D. That's the few who get lodge a complaint are seen as the courageous ones, and there are a number of who are suffering within the because of fear of losing what they have.
Yeah. So we need to. So you get a lot of people who after they've worked through their own fears of, well, not completely, they're still, I assume, would be quite fearful, but have overcome that. They've approached you, and they are prepared to go through the complaint process. Do you get people sort of starting the conciliation process and then sort of backing out, deciding not to proceed?
No, it's more like they feel like, look, this was a huge decision to come here in the first place. So,
yes.
Yeah. And they also the fear of the risk. So what they can ask for is informed by what they feel the other side is willing to entertain, with also the risk of what they can lose in the process.
Yeah. Natalie has said a specific right to housing within the Human Rights Act is a huge gap. I would definitely agree to that one. Matilda sort of alluded to the fact that obviously we've got, I think it was Matilda, maybe it was Bronwyn, some wonderful person participating today talked about how whilst there was no specific human right for housing, there are others that are breached or, limited because there is, based on somebody not having housing. But there should be I think, a specific human right to housing in our Human Rights Act.
Charlotte,
sorry.
Just to add to that, just for interest, you might be aware that in the ACT, the Greens have introduced a consultation bill, I think, introducing a right to housing in the ACT.
Yeah, I heard
Act,
some.
so.
They're doing a few things at the moment that are coming through. They're quite leadery, and I know that from the raise the age in terms of young offenders, well, it comes into effect, I think, July 1st. You mentioned to me the other day as well, and I was reading up a bit about that last week. So in the ACT, from July 1st, the age of criminal responsibility will now be 14. So that gets a huge thumbs up from me. So that's good to hear that they're also taking those first steps in housing as a human right as well. So hopefully we follow suit. Kirsten's asked, how do you balance the right to be housed and the right for safety in your housing? We hear stories of people in Department of Housing causing safety issues for other tenants, but eviction just puts them back on the street. Yes, so there's a lot of decision making around, who gets housing. I mean, you have a lot of, the department, we get a lot of applications for a particular housing. So, using the compatibility assessment about, the limit human rights that for each particular person who is applying, looking at each of their human rights and what's being limited in terms of needs and as well. So Kirsten, do you mean so somebody's already living there, but they're causing, they're impacting the human rights of other people through maybe discriminatory practices, or there's racism involved, or when you say causing safety issues for other tenants, does that escalate to police matters, or just looking to clarify?
Yeah, we often have people, and they may be dealing substances and that sort of thing. And so both the people who are feeling threatened and are threatening are in the Department of Housing, same coming into our spaces. And, at one point you're trying to not have them evicted and on the street, and on the other point you're trying to keep the people safe.
Yeah. And what have you done in those situations thus far?
I mean, we advocate for them both, you know.
Yeah, because they both have rights. I mean,
Yeah.
sorry to interrupt. You keep going.
Yeah, it's just you know, sometimes you just feel a bit conflicted when you're.
Of course.
Yeah.
Of course. I guess that, you know, it comes down to, I guess, how many people are affected by this particular, you know, resident causing those issues. I mean, there's a lot of things to weigh up. I don't know if, Rebecca, you have any thoughts on this.
Yeah,
I know that
just
a lot of decisions are made based on, you know, safety in general as a priority. You know, the more people to be kept safe as opposed to the you know, the one or few individuals, but I may be speaking incorrectly.
Yeah, I was just thinking about some things that Matilda said about trying to figure out the root causes of some of the
Yeah.
behaviours and whether those can be addressed through sufficient, you know, supports and other
Mhm.
Alternative strategies to address the concerning behaviour. The other thing that, and I might be getting the facts wrong, but I do recall in one of our annual reports we talked about an example, a case example of I think it was maybe a sister taking care of her younger sister in public housing. And it turned out it was exactly that. They just weren't getting enough supports. I mean, I think they did have to move them out of the current accommodation. I think that the accommodation that they were in became untenable, broken relationships and whatnot. But in the new space, Fresh Start, really working hard to make sure that there were appropriate supports. And I think this case study was that it had, at least at that stage, had been a successful relocation. And not creating the same problems that had existed in the original tenancy. So that was a really great outcome. But I imagine there was a lot of work putting the right supports in place.
What supports around the people that are causing these safety issues, and what, you know, conducting needs assessments. What are the underlying issues, and how can that be resolved without anybody being homeless? It is a very, it's a super difficult scenario, and I've worked in a lot of refuges and that sort of thing, but I'm in terms of, you know, deciding on who gets an actual place to live, that's not something I have a lot of experience in, but I can relate to certain parts of that question. So we've got approximately 7 minutes left. It would be wonderful to have some thoughts around what can we do, you know, as organisations in this community sector, so QCOS and QHRC, what we can do that would be helpful for the community sector in terms of resource development. So if anybody has any ideas about what we could do to provide further insights and education in this area, that would be amazing. I know I haven't left a lot of time. We've had a lot of things to cover. But if you do have any thoughts to share, that would be amazing. You can also send them through to me at charlotteb@qcos.org.au, and my email address will be attached to the post-event email. So if you have any thoughts around this, we'd be very interested in learning from you. So yes, unless anybody has any quick thoughts now. Yes, Wendy.
Hey Charlotte,
Hi.
I'm really just intrigued by the indicators that we talked about earlier. It'd be awesome if you guys could create, and I'm flicking it back to you so we all don't have to repeat the same thing, but do up some sort of template for providers to use to kickstart using those indicators when we're reviewing decisions or applications. Or my particular interest is, you know, from a compliance perspective. So when we're doing internal reviews on our policies, procedures, processes in general, are human rights being considered at every point of the organisation,
Mm-hmm.
that if QCOS developed a template that might help providers get that process started using those indicators as the basis for it. Because I just, just from the comments, there's probably at least half a dozen of us, if not more, that are going to go off and probably start the same piece of work.
Yeah,
Whether or not you guys could maybe facilitate that on behalf of all of us.
We have some resources around decision making in housing. I don't know if you've received any of the post-event emails from the last 2 sessions.
Yeah.
So we have some of those, and you can find them through the community door. But we also, I will have a look and see what we currently have. But if definitely, we will. I appreciate that very much. My mind is going now as I'm talking to you. So I'm going to look at what we have and look at putting together something like that. Because as you said, it would save a lot of time. And if everyone is about to go off their separate directions and start to have a look at what they can do in that respect, it would be to have a template to go off. That would be good.
Thank you for considering that.
No, thank you, Wendy. Thank you. Got another question now from Ames. Potentially having a spokesperson who can meet with organisations to yarn about human rights and how to incorporate them into the processes. The organisation that I'm currently doing my placement at is very relational. The way lots of work is done here is through yarns. So sort of having, Ames, correct me if I'm wrong, do you mean having something along the lines of workshops such as this, but face-to-face to build human rights knowledge? Yes, okay. Roger, I've got, okay. So yeah, we try and do these sort of workshops and regular human rights meetings to share knowledge, because it's, we can reach more people. And obviously because this session's recorded and the slides will be delivered, and the extra resources that I'll attach to the email following this, we try and do it that way, because it, as I said, reaches more people, not just the people who are actively participating right now, but other people can, this goes on YouTube and you can watch it at your leisure at another time. But face-to-face, there's something about a face-to-face that's really insightful. We've got, I don't know if you've heard of our town halls at the moment. They're going around the country at the moment talking, getting insights from particular regional areas as well as Brisbane. So we're currently collecting information and resource and skill building around domestic and family violence as well. So those are really good events to participate in if you watch out for them. We've also got our conference coming up in November, late November. As well. But yes, no, I appreciate face-to-face is a very sort of disappearing art form, but yes, I will take that.
Sorry, I was just
no, you go. I'm going to find my slide that I need.
The QHR, from the QHRC's perspective, I mean, we do have training that we offer, and you can find all those on our website. We have a very small community engagement team, so depending on what I don't know how they choose how to use up their resources for community engagement, but certainly supporting organisations to understand their rights is always a really, it's a goal. And we also, I don't know if it's a First Nations organisation, but we also have our Yurumba First Nations unit. And they're all about, going to community face-to-face, trying to create relationships and understanding around human rights. So if it is a First Nations organisation, I'd encourage you to reach out to our Yurumba team as well.
Thank you. I've shared a link. I'd love some feedback on this workshop, how it can be approved, etc., or how fabulous it was, either or both. So I've popped the link up in the chat, and I'll also send it out in the post-event email. But if you could take some time to give us some feedback, we would really appreciate it. That would be amazing. We're totally out of time. I appreciate you sticking around very much. I would love to thank Joseph and Rebecca, Bronwyn and Matilda for their amazing insights today, and to all the participants today. It's been amazing having your discussion and your feedback. We've got a few events coming up, which is tackling social isolation and loneliness and how community-led innovation can make a difference. That's coming up on tomorrow. As I mentioned before, we've got our QCHRC town hall, so have a look at the events page for dates and locations. I'll be meeting with the Human Rights Commissioner on the 8th of July. Please sign up for that if you haven't heard about it already, just under the events page on the QCHRC website. And as I mentioned, we do have our amazing QCHRC conference, Changing State. That's on the 25th to the 27th of November. So please explore that and register for that if you are interested. And that's my email address if you need to send me through your wonderful ideas for what resources can be further developed. Do any of my wonderful presenters wish to add anything else before we say goodbye? No? Thank you again to each and every one of you. I honestly appreciate your time and energy today. It's workshops such as this that, you know, keep those human rights conversations going and help us to continue to build on human rights respecting practice. So thank you again very much. Bye.